Good afternoon. Just giving a quick recap about what we covered today during our weekly webinar with respect to COVID-19 and workers' compensation. Today we covered whether or not certain COVID-19 related illnesses and injuries that arise out of the scope of employment are covered by workers' comp. We discussed the general rule, which is the workers' compensation exclusivity rule, which means that generally any illness or injury that arises out of the scope of employment is covered by workers' comp. This means that employees or former employees or their families cannot bring a lawsuit against the employer for injuries sustained arising out of the scope of employment, illnesses or injuries arising out of the scope of employment. They must bring them and be addressed within the workers' compensation forum and the workers' compensation board. There are certain exceptions to this rule, most primarily going to be the intentional tort exception, where an employer intends deliberately to cause some injury to the employee. Mere knowledge of an existing hazard will not arise to be sufficient. We talked a little bit about the Palmer versus Amazon case, which is a New York case, which is currently pending appeal at the Second Circuit. Employees brought a lawsuit against Amazon claiming that the employer did not follow local, federal, and state safety precautions, and which led to employees contracting COVID-19. And the court ultimately dismissed the case. The Eastern District, which is a federal court in New York, dismissed the case, finding that the employees were barred by the workers' compensation exclusivity remedy, meaning that the employees had to bring the claims for injuries and illnesses sustained in the course of employment, namely COVID-19 here, in the workers' compensation forum. They also discussed, the court also addressed the primary jurisdiction doctrine, which essentially means that these types of claims are better suited to be addressed by an appropriate administrative agency as opposed to the courts, alluding to OSHA as the administrative agency that is better suited to handle these types of complaints. The case is currently pending appeal before the Second Circuit, but we don't necessarily anticipate to see any differentiation with respect to whether or not COVID-19 claims that happen in the workplace are an exception to the exclusivity rule. We also talked a little bit about the California case, See's Candies, which is a little bit different in the sense that the court in California found that the derivative injury doctrine did not apply in that case. A little bit of background: an employee was employed by See's Candies working on an assembly line. She brought a claim against her employer, See's Candies, because she contracted COVID-19 allegedly in the course of employment, brought it home to her husband, who subsequently passed away. So she brought a claim on behalf of her husband, essentially that he was he died as a result of the employer's failure to adequately protect the employees, which then caused his death by virtue of transmission of COVID-19. The court found that the derivative injury doctrine did not apply. The derivative injury doctrine essentially stands for the principle that any types of claims like loss of consortium claims, loss of companionship claims, etc., that are sustained by a family member are directly related to the injury of the employee and therefore are covered by the workers' compensation exclusivity remedy. Here, the court found that the derivative injury doctrine did not apply because the husband of the employee suffered his own independent injury. It was not an injury related to the employee's injury. So that is also pending appeal, and we will see what happens there. It wasn't decided on the merits. So we will see what happens in the See's Candies case, but ultimately, our best advice is that the workers' compensation exclusive remedy rule still applies. Generally speaking, we haven't seen much deviation from that. Continue to follow any applicable health local health, state and federal guidance with respect to COVID-19. And remember that you still have a general duty to protect your employees and maintain a safe and hazard-free work environment.